case someone says you did something that you didn't do. In this case, I was shot at. My dog was shot and killed, and my wife was shot at. Now, did Mr. Laxton know that he was shooting at her?
Your Honor, at this point, I object. It's not responsive to the tape. It's argument.
You need to, since he's objecting, you need to ask yourself a question and then respond to the question.
Mr. Parsons, in reviewing the tape, was there any information on the tape that would support your frame of mind at the time as it relates to you being shot at and your family being in jeopardy, which prompted your assertion or your action to seek a citizen's arrest? Yeah, the whole concern about gathering people to come to be witnesses because we don't trust law enforcement. We wish we could. The history shows we've been attacked, shot at. We've called the police several times. Nothing's done. 3 of our dogs have been killed. Nothing's done. And you ultimately have very little recourse in that matter. So you seek guidance from people. You call people that you know that are law enforcement or paralegals to seek their advice. And in having a conversation, there's a lot of things discussed. Did we get my wife's guns out of the house and my computer and some of the documents related to the election? Yeah. Is that a crime? No. Nothing on the tape supports any assertion by the state that what I did in telling these people to stop shooting, to put their guns down, or that they're under citizen's arrest. The 3 things that I said immediately upon walking down there, there's nothing illegal about that. You have that right under the law. Once you enact a citizen's arrest, they're supposed to submit. And if they don't, well.
Yeah, I will object at this point.
Yes, objection be sustained.
Mr. Parsons, on the tape when you said I had the gun drawn on him, who are you talking about?
I have no idea.
You don't know who you were talking about?
I was talking
I had the gun drawn on him.
I was talking to Jim Jones. I don't know who I was talking about.
Well, there's only 2 possibilities, isn't it? Did you draw a gun at a 3rd person that day?
No.
But you don't know who you meant when you said I had the gun drawn on him?
I don't.
Okay. And what did you, this Jim Jones, is he a legal advisor of yours, a mentor? What is he to be the person that you would have first called?
He's a retired paralegal. He's been in practice, I think, 40-something years. He at one time was a doctor. He's a very well-versed, very well-schooled historian. Just a wealth of information, friend of the family for many years.
So what did you mean when you said, what do I tell them?
I don't recall exactly what he was talking about that prompted that question.
Because obviously you should only tell the truth and not have to ask directions from someone about what you tell. Would you agree?
I'm not going to speculate because I can't recall, but I'd like to call Jim Jones as my next witness.
And I'm sure you will, Mr. Parsons.
We'll find
you
out.
Well, I don't know that he can answer the question about what you
I've
meant.
listened to that recording twice in the last 2 years. Both times have been in this courtroom. I've heard it once just days after the event. I haven't listened to it since then because it wasn't a part of this situation. And if that was given to Mike Robbins or Miss Mills and you subsequently obtained it.
Mr. Parsons, you handed it to me.
Not that part.
That's all.
Thank you, sir. Mr. Taylor.
If Jim Jones is here, I'd like to call him at this time.
explains citizens arrest, but it's on June Drive.
What's it called?
You can pull it up.
What file is it?
It's under citizens arrest. Okay.
How'd I do?
I thought you did pretty good.
Sure.
I built your foundation. Same address. Did you talk to him that night? What time you called him?
How bad did I do?
You did great, I think.
Please state your name for the record, sir.
James Michael Jones.
Good afternoon, Mr. Jones. Would you please state for the court your experience as it relates to the legal field, as your training and work record and knowledge of the law?
Well, I've spent 35 years in the legal profession as a paralegal. I understudied now deceased criminal court judge John Copeland in Memphis.
Have you known me for quite some time, Mr. Jones?
I think 4 years maybe.
And on September 24th, and you've been friends of the family, though, through Chip Ward, who's
Oh, yeah.
in the Henry Ward for
20 years.
Yeah. So we've had a knowledge of each other, although we haven't been communicating on a daily basis per se.
That was correct, yes.
Would you please recall your accounts of September 24th, 2007? Could you please speak of that afternoon, and specifically meeting that we were having and what we were discussing at that meeting?
Well, actually, we had met at a restaurant in Arlington, and we were discussing a few things. And at that point, you got a phone call from your wife, and you just informed me at that point that you had to leave, that something had happened at home. And other than that, I didn't know what it was or anything like that. I figured since you had to leave immediately, it was something quite important.
Were you talking to me at that meeting relating to preparing for an appeal on a challenge to the election in Tipton County?
Yes, that was discussed.
Okay. And when I rushed away, did I call you back later that evening?
It's been so long, but I believe there were 2 phone calls. One was, I think the first one, rather short. I think at that time you kind of highlighted the incidents that had taken place. And you had asked me something about the firearms or the guns or something. I asked you that. I said, well, have you turned your firearm over to the sheriff's deputy? And you said, yes, you have. I said, what about the other people involved? Were their guns also turned over to the deputy? And I think, as I recall, you said yes. And then there was some other questions there. But the reason I asked you that whether you turned guns over to preservation of evidence, of course. But then the rest of the conversation, I can't really recall.
It's been a couple of years, and
yeah, there was a second conversation which you called, and you were asking me about the case that we had been previously discussing, which was an appellate case. And I made a suggestion at that time, I think, that you said something about the police wanted to come and search the house.
Was it that, or was it I was concerned about the police possibly coming and...
That may have been in there also. But there was, in the conversation, I remember that the appellate case was mentioned, and I said, that evidence, if you think that there might possibly be the probability or possibility that the police or the deputies might, for some unknown reason, remove that evidence, I said, just get it out of the house. And I said, if you want to bring it over here, I'll be glad to get it for you.
Right. And you weren't aware of this, but I had a little thumb drive recorder around my neck at the time, and it was still recording. And we had a conversation, and you were saying things, and I was asking questions or making comments and such. And it's been 2 years, and I can't remember exactly all the things that we spoke about either, because I didn't think it was important. But is it not a fact that I contacted you immediately after this event and told you about the event?
Yes, I believe that was the first phone conversation.
Did I tell you that I'd been shot at?
I believe you did, yes.
Did I tell you my dog had been shot and killed?
Yes.
Okay. And seeking your advice at that time, and of course, I'm sure your recollection is as fuzzy probably as mine, because never really thought that that conversation would need to be remembered. But do you recall me seeking advice relating to what should I do?
I remember something to that effect. But as I'm sure that you may recall, if you look back, at one time or the other, I said, I don't give legal advice. I can make suggestions
Right.
in that. Or I can tell you what I would do.
Right.
Under the same circumstances.
Right. And you've lived in the West Tennessee for quite some time now.
For about 12 years now.
Right. And your knowledge of the courts and the people that work in law enforcement, sheriff's departments in various counties, and you've interacted with these people through the years, is that correct?
Yes, of course.
And in my case, would you agree that it was prudent to be cautious about what the police may or may not do if they come to my home?
Prudence. What would be prudent? Police officers, and I think anybody in this courtroom, you pick up the newspaper, and almost every week you'll find newspaper articles about wrongdoing involving police officers. Look at the case down in Memphis of the man named Tormini, and then the police officer, the 3 police officers were going to break in, burglarize, and rob celebrity Jerry Lawler's home. So policemen aren't any more credible, believable than anybody else. They have the same misgivings, the same failings as we all do. And I've known a good many police officers. Some of the very finest men I ever knew were police officers, Texas Rangers. I have friends on the Memphis Police Department now. But all of these people that I know, these are straight up and down arrow guys. But that doesn't mean that all policemen are that way, because they're certainly not. And I've been involved in a periphery of cases. One that comes to mind immediately was a man by the name of Benjamin Steiner in Harris County, Texas. He was a gun collector. He had some very expensive, one-of-a-kind firearms. One of them worth $240,000. Came out missing as a result. The police cannot arrest him on that failure to appear warrant. And during that process, the gun disappeared. Now nobody knows who got it, but the Texas Bureau of Investigation eventually traced it back to one of the arresting officers in South North. So these are just examples. I certainly don't mean to deride or debase police officers at all, because they're some of the hardest working people. I certainly wouldn't want the job. And there are a necessary force. And but that's like every other profession. There are bad apples.
So my concern would be reasonable then if that knowledge be known to me, that I did have something because, and you're a student of history to a great degree, is that correct?
Somewhat.
And you're familiar with guns to a great degree. You're familiar with the Ferguson breech loading rifle?
I've had some contact with it, yeah, not much.
And I believe that we had a conversation that my wife, whose ancestors settled Collier
Your Honor,
County.
at this point, I've exercised too much restraint perhaps, but this is getting far afield. I object to the relevance of
Objection. Objection to be sustained.
I was only going to the acknowledgement of antique weaponry that my wife possessed that would be a great concern if someone came in and tried to steal it.
Hey, ladies and gentlemen, while the defendant who represents himself was under oath and testifying, what he said was evidence. Our comments, once he assumes the role of pro se representation again, his comments are not evidence. To be considered by you only as the supplies meeting to the testimony given by witnesses, which is the evidence in the case.
Thank you, Mr. Jones. I appreciate you taking time out of your day to come in today.
no question.
Thank you, sir. Ready to go back to business. Call your next witness, please.
No more witnesses, Your Honor.
State any other witnesses? Okay, ladies and gentlemen, that concludes the proof that you're going to hear in the case. We're going to take a break, and during this break, I'm going to go over with both sides what I anticipate charging as the law. When you come back into the courtroom, you can hear closing statements, receive the charge, and then you're entitled to decide the case. But until that time, please don't begin discussing the case among yourselves. Back to let you know when it's time to come back in. You can step out to the jury room.
Okay. Okay. Now, when I see, I got someone just saw and trespass, just in case. So it's
Take a short break before we go to the jury proposed to be charged and the opportunity to organize the closing statements. Stay in recess for a few minutes.
All rise.
okay, a few minutes. You can want to do it.
We'll try that.
Hey,
That's what I told him.
Okay, you take care of it. I'll let it go.
okay, and the 911.
All right, now listen, Mike. I did throw some stuff on your closing, and it's up to you to look at it if you want to.
You think short and sweet closing, or
I think you just hit some points.
they haven't met the burden?
Yeah. It doesn't bother you. The state never considered it. Just doesn't bother you. They never arrested Barry Langston. Doesn't bother you. They never ceased King's gone. Doesn't bother you. They never turned to talk to you and lie. Okay, your reality has a lot to do with it. I'll take it.
How much time we got for this come back? I was going to go out and talk to my family.
duties of the court and juries, formal charge, denied evidence, statements and rulings in court, statements and arguments of counsel, the juries and judges, the facts and law, presumption of innocence, burden of proof venue, elements and date of the offense, reasonable doubt, the pattern instruction for aggravated kidnapping as a lesser included offense, kidnapping, and false imprisonment. It's a state no need of a lesser included.
Your Honor, Mr. Parsons seems to be arguing that he was not actually able to effect the arrest and perhaps an attempt of those 3 charges.
All right, so, Ms. Mills, I know you've been instructed not to assist any longer, but I was hoping perhaps you had had a chance to maybe go over possible jury instructions with Mr. Parsons. Otherwise, I'll just ask Mr. Parsons, are those lesser included satisfactory with you?
You just mentioned attempted aggravated kidnapping, attempted aggravated kidnapping, false imprisonment. Yes, that's fine.
What does that mean?
He's not only get felonies and the attempted.
He's seeking to add charges.
No, those are misdemeanors. He said these are lesser included offense. So he said he's going to add false imprisonment, and that was part of ours today. False imprisonment. He's going to give them that instruction too, and that's a misdemeanor. That would be great.
But those charges still stand, right?
All he's saying is I'm going to give it for aggravated kidnapping, I'm going to give it for kidnapping, false imprisonment. And Mr. Freeland said, well, would you put attempted aggravated, attempted kidnapping? And the judge said, okay.
So what am I supposed to do?
You're okay with that? Joey, you're okay with that? Yeah, I mean, it's good. Yeah, it's a misdemeanor.
I don't know what to say, Your Honor, but I assume that that's Your Honor's choice and Your Honor's decision in this matter. What do I do? Present these? Your Honor, I have some proposed instructions.
Yes, we're going to get to that in just a second.
Give John in just a second.
And in the next count, aggravated assault as a lesser included assault. State knows any lesser included besides that.
No, sir.
Defendant knows any.
No, that's good. He said he's going to do aggravated assault and do the assault misdemeanor as a lesser included offense. No, he said he was going to do that. He wanted to ask him if he didn't say that. He's going to do aggravated assault felony. He's going to do simple
I
assault.
don't understand. I thought he was saying to you, does he want to do that?
Yes.
Said no.
Judge, we had some disagreement. I believe when you said assault as a lesser included, the state said okay, and we're saying okay. Or you're saying okay.
I misunderstood. I thought Mr. Freeland said no.
I have no problem with it, Your Honor, although conceptually it makes no sense. It's either an aggravated assault or nothing. To just be perfectly fair to Mr. Parsons, I got no objection to it.
And then in the next count, over the vehicle with no lesser included, since that's property with no lesser included.
Okay, so lesser included in those two. Okay. Unless. Okay.
The defendant is indicated through his pleadings and also through statements that he's requesting self-defense as a defense. Is that correct?
Self-defense and citizen's arrest.
Yes, sir. And the court will then charge self-defense. Also, the court anticipates charging arrest by a private person, which is known as citizen's arrest. The provisions of TCA 40-7-109, arrest by a private person. The provisions of TCA 40-7-111, arrest by a private person, notice of grounds. And the provisions of TCA 40-7-113, disposition of a person arrested by a private person, together with some explanation taken from the case law with regard to citizen's arrest or arrest by a private person.
Your Honor, was that 40-7-111?
Yes, sir. That is, that caption is arrest by a private person, notice of grounds.
There's also a 40-7-110. And a 39-11-621, use of deadly force by a private citizen. Should I include these instructions here?
All right, the special request has that you must find him not guilty by reason of arrest. Citizen's arrest is not a defense. It's merely an explanation of the law, and it'll be up to the jury whether the defendant acted within the provisions of the citizen's arrest law.
Bless you.
The portion of defendant's request which I'm reviewing indicates that he's requesting the provisions of 40-7-112, which has to do with entering a dwelling house, saying that if the person to be arrested has committed a felony, a private person, after notice of the person's intention to make the arrest is refused admittance, the arresting person may break open an outer or inner door or window of a dwelling house. The court will not give that request. That statute is fact-specific. It's limited to the statutorily prescribed circumstances and does not authorize a private person to engage in conduct made unlawful by other statutory provisions. That's in a number of cases, to include State versus Kersey at 2006, Tennessee Criminal Appeals 521, together with some very old cases that are cited in that case. So the court will not give that provision. The citizen's arrest or arrest by private person provisions do not authorize the commission of a tort on a citizen, and the court stated that any other view would lead to more violence than it would suppress. Continuing with the charge, evidence, direct and circumstantial inferences, dogs running at large, the witness instruction to include impeachment instructions, the character of the defendant, identity fines, multiple counts finding on each required deadlock jury charge, no sympathy or prejudice, selecting a core person, finding and reporting by use of forms, breaks, questions, concluding instructions.
But the state would waive the jury determining fines.
Is that satisfactory with the defendant?
Yes, sir.
And defendants request the provisions of TCA 39-11-621. If that code code site is correct, in any event it reads, private citizen making an arrest authorized by law may use force reasonably necessary to accomplish the arrest of an individual who either flees or resists the arrest, providing that a private citizen cannot use or threaten to use a deadly force, except to the extent authorized under self-defense. Okay, are there anything else that we need to cover before we have closing statements?
Judge, I think that Mr. Parsons may have some issue about the lesser included offenses, and I don't know.
I was unaware of this and wasn't prepared to necessarily argue them, so I'm kind of at a loss. I don't know what to do. And I haven't been provided any copies of any lesser offenses to review, so I don't know the standards of what they are. I would simply ask, if nothing else, to be provided a copy of the statutes for review.
Okay, let me go over them with you real quick so you'll have an understanding.
Is it possible to get a copy of them printed just to be able to review while I'm doing my closing?
Your elbow counsel has a copy. Aggravated kidnapping, the elements are that the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty, and that the defendant possessed or threatened the use of a deadly weapon. Two elements. The lesser included kidnapping would be that the defendant knowingly confined another unlawfully so as to interfere substantially with another's liberty, and that the confinement was under circumstances that expose the other to substantial risk of bodily injury. Let me look at that. then the false imprisonment, the elements are that the defendant confined another officer so as to interfere substantially with others' liberty, and that the defendant acted knowingly. So aggravated has an element of using a weapon. Kidnapping does not, and neither does false imprisonment. The criminal attempt is attempt to commit one of those crimes, that is not carrying through with it, but attempting to do that. Aggravated assault is the elements are that the defendant intentionally knowing the cause another for reasonable fear of imminent bodily injury, and number two, that the defendant used or displayed a deadly weapon. Assault is the same except there is no weapon. It is the defendant caused another reasonable fear of imminent bodily injury, and the defendant acted intentionally knowing it. Burglary of a vehicle doesn't have any lesser included. I don't believe on the facts of this case that neither does theft of property. Is that satisfactory for an understanding of the differences?
I guess it'll have to be.
Is there anything else we need to take up for the jury's brought back in?
Can we move to dismiss the burglary and the theft at this point? Or move to dismiss?
Would you like to make that motion?
Yes, sir. I'd like to move to dismiss all charges, actually, but these lesser included offenses, the firearm, obviously, and the paddle holster was returned immediately to police officers. They're here today in court. The vehicle was wide open. The truck was open. Testified that it was not a breaking and entering. It certainly was a situation where confiscation of the firearm that was used to shoot at me and my family was a necessity and a part of effecting the citizen's arrest to contain the threat. And given the fact that the property was immediately returned, the elements of theft is that my intention was to deprive them of their property and hold it or keep it, and that was not the intent. The intent was to prevent them from shooting me and to be able to show a law enforcement officer that, yeah, the guy had a pistol, here's the paddle holster that matches it.
Okay, Joe.
I believe the jury question has been presented on all charges.
Court leaves it's up to the jury to determine what the facts are. Is there anything else? Each side has no more than 30 minutes to present your closing statements to the jury. You can ask the jury to come in, please.
Your Honor, can I ask one question?
Yes, sir.
Just because I don't know,
Yes.
from a mechanical standpoint, I understand that the DA is going to start closing arguments,
Yes, sir.
and then I'll do closing arguments,
Yes, sir.
and they'll do closing arguments all over again?
Yes, sir. They have a total of 30 minutes. You have a total of 30 minutes on your side. You don't have to use it all,
Okay,
but no more than that.
thank you.
Yes, sir. Anything else?
No.
Okay, ask the jury to come in, please. Sit, please. Okay, ladies and gentlemen, at this time, each side has a right to address you by way of closing. You're reminded that what's said in these statements are not evidence. You have to make your decision again based on the sworn testimony, the charge of the law that I'll give you in a few minutes, and then you decide what the facts are based upon the testimony of the witnesses, and you apply the law that I give you to the facts as you find the facts to be. You're the judges of both the facts and the law. You're the judges of the law because it will be up to you to determine, after you determine what the facts are, which law then to apply. Each side has a right to address you, to tell you what they believe is very important in the proof, and why they feel like your verdict should be one way or the other. The state has a right to address you first, then the defendant can address you, then the state can make a brief rebuttal argument if they choose. Joe?
Thank you. Take this opportunity to really thank you for your service today. Jurors, today and 2 days before. This has been a difficult trial. It's difficult in part because you have a somewhat unusual situation where the defendant is also the attorney, and that raises all its own problems. Now, I ask certainly that you not hold against Mr. Parsons if he is not as familiar with the law, obviously, as an attorney would be, and not hold that against him. You've heard the indictment read. The indictment's just a charge. The grand jury said this is a charge. It's for your consideration. And what you are to consider is whether the state that Tennessee has carried its burden of proof. That's what you consider on each of these counts. What happened on September 24, 2007? Obviously, some are more important than others. The theft of a .22 rifle, the theft of an insignificant sort of a holster for a pistol, even the burglary of a vehicle is not as important, obviously, as the aggravated assault alleged on Barry Laxton and Nick King, and the aggravated kidnapping alleged on Barry Laxton and Nick King. And I suggest to you that regardless of what Mr. Parsons says about this, this is really a case that depends on 3 witnesses. There are 3 witnesses that were there: Mr. King, Mr. Laxton, and Mr. Parsons. So, obviously, I suggest to you the most important thing is who do we believe? Because people, I suggest to you, are saying more or less polar opposite things. They're saying different things. Now, the judge will tell you that all witnesses are presumed to tell the truth. But at some point, people are going to say different things. And you're going to have to make a hard choice. And I suggest in this case, you're going to have to make a choice between 2 extreme positions. Somebody is lying. Somebody is telling the truth. They may shade in some insignificant details, but if these people's testimony is to be believed, you have to believe somebody and not believe somebody else. And how do you do that? The judge will tell you what your comments will tell you. It's credibility of witnesses. And he will tell you, that's a fancy word, why do we believe somebody over another? Why do we believe somebody over another? It's your common sense experience of looking somebody in the face, judging them. Does this make sense? Does that make sense? Think about the testimony of Nick King and Barry Laxton. And if they were somewhat taken aback or off guard, it's because of the situation you put yourself in. They're being cross-examined not by just the defense lawyer, but by the very person who put a 9mm block handgun in their face. I want you to consider that when you consider if they were upset or nervous or whatever in their testimony. They are being twice victimized. The defense attorney who is cross-examining them is the person they say stuck a gun in our face. And also, I suggest to you, you look at the reality, how one perceives reality. Because I suggest to you that you may even believe that Mike Parsons thinks he's telling the truth, but that his reality is not the reality of other folks. Here's a person who the year before is defeated in an election 70-30 and thinks the figures were flipped. 70-30. Now, this doesn't matter except to give you an idea of what his perception of reality is. His reality, I suggest to you, is not other folks' reality. If you were the judge of his credibility and whether he perceives reality, was he evasive? That would be one of the things that the judge will ask you to consider. Was he evasive in answering? Did he seem to have his own agenda, which he was going to forward at every opportunity? does this grand conspiracy sort of scheme of his, in which there's a good old boy network that hides dogs and does all this and manufactures the evidence, does it make any sense? Now, to treat animals like people, that's a good thing. That's a good, decent thing. But when you start treating people like animals, and you don't know the difference, I suggest that your reality is skewed. Your perception of reality is skewed. And Mr. Parsons is trying to make this about what he termed the murder of Randy Parsons. Now, Randy is part timber wolf, part Arctic wolf, part husky. And that animal's death is not what is on trial. What's on trial is his response. And he would suggest to you that he had a right as a citizen to leave his property, to go 700 some odd feet on somebody else's property, to hold two men at gunpoint. Now, the judge will tell you about the ability of a private person to effect an arrest. And to use deadly force, there has to be self-defense. Self-defense. Mr. Parsons would suggest to you, I left my residence, went through that woodland, went through that field, went 700 feet and better on somebody else's property to put myself in a position of danger to assert self-defense. Now, you heard Nick King testify, and you heard Barry Laxton testify, and you were the judge of their credibility that that man was not at any point ever in danger or shot at, that he was not even seen by them until after that charging wolf, the wolf that was charging Mr. Laxton, had been shot. And it matters not whether the bullet fragments found in the spine or in the abdomen, which was missing during the autopsy, or in the face or in the chest. That's got nothing to do with nothing. Put yourself in Barry Laxton's position. He's got a wolf chain. Now, perhaps the wolf is going to come, put both paws on his shoulder, and give him a big old lick, because he's such a gentle animal, Randy. But Barry Laxton couldn't know that. All he saw was an animal charging at him. And if you got a gun, and it's got a bullet in it, what are you waiting for? Why are you saving? You got a better situation than a wolf running at you to use that? Barry Laxton had every right in the world to kill that wolf. But that's not what's on trial, but it's his actions, Mr. Parsons' actions. And he made a recording of the very event. So you have the opportunity to hear it. And this is another thing about perceptual reality. You listen to that. Does that in any way show a man of composure, Mr. Parsons? Does that in any way show a man trying to defuse the situation? Does that show in any way somebody that thought bullets were whizzing past his head, or that his wife was in danger, or that he was in danger? That tape shows a man that's mad that his wolf has been killed. He's taking the law into his own hands. And he's doing it by means of a 9mm Glock handgun. And you cannot use deadly force unless you've got a badge that you've earned, unless it's self-defense. There's no evidence of self-defense. None. But Mr. Parsons' self-serving sort of statements. Now, you remember that tape, and you'll have an opportunity to hear it. Nowhere does he say, you were shooting at me. You were shooting at my wife. What does he say? When he's had a chance to collect his thoughts, when he's had a chance to leave, he doesn't affect the citizen's arrest, he leaves him. When he's had a chance to leave, he starts working on his story. Yeah, they shot at him. I'm calling my friend the paralegal. Yeah, they shot at me. They put a cord around my neck. They shot at me. They were shooting at me. Shooting at me. But that's not what he says in the heat of the moment when it's happening. Doesn't mention it because it didn't happen. And we know that because Barry Laxton testified that it didn't happen. And Nick King, who saw it, said it didn't happen. So the only person that says that it did happen is the person that's got an interest in your buying a self-defense claim. And that's Mr. Parsons. The other folks, they have no dog in this fight other than being victims. It's Mr. Parsons that starts to put his views together, gather together his legal defense. If there was no reason in the world, I submit, to arrest Barry Laxton. The man was doing what anybody would do, which is kill the charging animal. But if there was no reason to arrest Barry Laxton, how much less of a reason was it to arrest Nick King? There was no reason at all to arrest Nick King. On the audio tape, you heard it referred to as I got a witness. There's a witness. Some guy shot my wolf or my dog, and there's a witness. You don't go around arresting witnesses. There's no citizen's right to arrest a witness. Who's going to determine this probable cause? Whose reality is going to come into play to say there's probable cause for there to be arrest? Mike Parsons. That man's reality is going to judge whether he has the probable cause to arrest. But the judge, if he makes that choice as a private person, not a citizen, you cannot use deadly force unless it's valid self-defense, and it's not. Now, aggravated assault is pointing a weapon at somebody so that they reasonably fear imminent, that is just soon, anytime, serious bodily injury or bodily injury. Is there any doubt from the testimony from that audio tape that Nick King and Barry Laxton, when that man pointed a 9mm Glock at them, thought that they just might die any minute? That's what an aggravated assault is. It didn't even have to be a loaded weapon. It was. The proof was. But when you point, whether it's at the head and you can see the spirals of the barrel, as there's been some testimony, or it's at the core of the body, you know what a 9mm can do from a short distance. And you're the judge of credibility of who's telling the truth, whether it was a matter of 2 or 3 or 4 feet or 35 feet, who's telling the truth there. And I suggest to you the proof is overwhelming that they were in danger and perceive themselves, rightly so, be in danger. 5, 4, 3, 2, 1, or I'm going to shoot you. And it was a real gun. That's when you're going to fear for your life. You don't know if you got 10 seconds, 5 seconds, what your time left on this earth is. And that's because of Mike Parsons, who considers himself the law south of the hatchet. And he's putting these people in danger. Aggravated kidnapping is confining somebody so as to substantially interfere with their liberty. Vegetative. Confine somebody, keep them from moving around so as to substantially interfere with their liberty by use of a deadly weapon. No question, a deadly weapon. Were they confined? Was it a substantial interference? Think about this, ladies and gentlemen. This isn't a classic situation where somebody is kidnapped, held for ransom, and a note sent, they're held for 2 weeks. It's up to you, the citizens of this community, to decide, is it a substantial interference with somebody's liberty to have a gun pointed at them, to say, lay down, get on the ground, I'm going to count from 5 down to 1 and shoot you. You can't leave, don't move, stay back. For a period of, you didn't listen to the tape, it's about 4 minutes. But at my second argument, I'll get a chance to address your plight. I want you to think about what 4 minutes is. If you're watching a comedy show on TV, 4 minutes is like it. If you got a gun pointed at your head, 4 minutes doesn't go that quick. It's a lifetime. Literally, it might be a lifetime. And I want you to think about what Nick King and what Barry Laxton felt when they didn't know if they were going to live or die, and whether 4 minutes is a substantial interference with their liberty. You say that it is, and suggest the proof is that it is. Mr. Parsons is guilty. Listen carefully to the elements of the crime. He's guilty of the aggravated kidnapping of Barry Laxton. He's guilty of the aggravated kidnapping of Nick King. He's guilty of the aggravated assault, the way he did shoot Nick King. And he's guilty of aggravated assault, even though he didn't shoot. Very lax. He went into the F-150 pickup truck without permission, just as he had trespassed 700 plus feet on somebody else's property. He trespassed into the truck of Nick King, got something he couldn't get. Now, if you have a common idea about breaking and entering, that you have to break a window or a chimney or lock, you don't. You just have to go into a truck without permission, which is what he did, and take something, or with the intent to commit theft, which is what he did. We don't have to be concerned with his intent because we know what he did. He took a holster. Now, if he can suggest I took the 22 because I was in danger, I suggest to you he can't make that argument on the holster. The holster wasn't a dangerous item of contraband. He just took it. But what did he intend to do? Now, he said he objected because it's prejudicial, which I suggest it is. But on the rest of the tape, which you heard later, it suggests what he meant to do. And he said, do I hide the gun? Talking to his legal counsel for legal advice. Do I hide the gun? I don't trust the police. What do I do? What shall I tell them? Listen, your memory will recall he asked somebody later, what shall I tell them? Why in the world would you call somebody and ask them after this event, what shall I tell them? Other than hiding something or telling a lie. And on that tape, after the event, when he's gone to the house and he's calling for advice, he also, and you'll be the judge of the facts and what's said, he also says, hide her. Hide her. What in the world could that be? He's saying, hide her. Think about all this, ladies and gentlemen, jury, and I think at the conclusion of your deliberation, you'll have no choice. But giving Mr. Parsons every benefit of the doubt, take into account that he's not an attorney, and judging the facts from the witness stand, and to separate the facts from the witness stand as best you can from what may be questions from counsel. You'll have no hesitation, no problem in finding Mr. Parsons guilty on all counts. Thank you.
Sleepless prepared. That's what you do when you don't feel like you get a fair shot. You have to take responsibility. Right now, you're the judge. You judge the law and the facts, and the judge has actually acknowledged that. That is the fact. On the night of September 24th, it was my understanding that I had the duty and the right and the obligation to enact a citizen's arrest to protect my family, based on the imminent situation I was in. My training